hearing State of Georgia versus Robert Olsen, 16 CR 1181. Ms. State, ready to proceed?
Yes, Your Honor.
Is the defense ready to proceed?
Yes, Your Honor.
All right. Ladies and gentlemen, we are getting ready to start the citizen hearing. As I previously stated before, understanding that this is a criminal case and emotions run high, if for whatever reason you do not feel that you can compose yourself and keep your emotions together, what I would ask is that you would escort yourself out of the courtroom and gather your emotions and gather yourself in the hallway. Once you do that, we will be more than happy to have you back in the courtroom. Also, please remember that there's other court business going on, and so we will not do anything that would interfere with other courts. Additionally, if you have an electronic device and you have not previously submitted a Rule 22 that has been signed and authorized by me, everyone, including attorneys, will need to turn their electronic devices completely off. If it goes off, then you will be escorted out of the courtroom until you can come in compliance with Uniform Superior Court Rule 22. If you have any question, there's signage on the door. Additionally, if you have gum or candy in your mouth, if you will please properly dispose of it by placing it in a trash receptacle or some scratch paper. Mr. Johnson, I'm ready to proceed.
Yes, Your Honor. One of the first things that might be appropriate to address is the issue of the count. I know the defense filed something yesterday, or the day before yesterday, on Wednesday, that brought up the issue of merger. And so I thought it might be appropriate if the court allows for us to just argue that issue.
Absolutely.
So, Your Honor, the state's position is that those counts do not merge, and we're talking specifically about counts 5 and 6. Those are the counts that we have been noticed by the defense that they intend to argue do merge. And so the defense cited in their brief a couple of cases, Gibson v. State, GIP-SON 332, Georgia Appeals 309, and Drinkard v. State, which is 281, Georgia 211, or Drinkard v. Walker, I should say, 281, Georgia 211. And so we don't disagree with case law, in other words, that applies here. I think that the difference will be in the application of that law or the rule to this case. The court is aware that in the state of Georgia, they have changed the test for merger to basically a required evidence test. Prior to that, it was a bit different, but now it's under the required evidence test, and it's well laid out in Gibson as to what the court should consider. And what is most compelling, I think, is that what the test is, that under the required evidence test, neither offense is included in the other if each statutory provision requires proof of a fact which the other does not. Consequently, when each of two statutes requires proof of an additional fact which the other does not, an acquittal or conviction under one statute does not exempt the defendant from prosecution and punishment under the other, even though the charges are based on a single act. And that's directly from the Gibson case. And the state's position is that in counts 5 and 6, you do have different required information or elements that needed to be proved to make this not a murder. What I would point the case or the court specifically to is that the count 5 for making a false statement, that the elements are that the defendant falsely claimed, one of them is that the victim, Anthony Hill, physically assaulted him prior to the shooting by pounding on his chest, and that this was done and made to Officer Anderson in the investigation into the shooting of Anthony Hill, a matter within the jurisdiction of the DeKalb County Police. And then in count 6, you have the violation of oath by public officer, and that in that you have that Officer Olsen at that time did swear, and it has the language from the oath that he swore to, and then made a false statement to Officer Anderson, and there's additional elements there that it was in an effort to fabricate a justification for the shooting of the unarmed Anthony Hill and in violation of OCGA 161020, which is a false statement, and in violation of the DeKalb County Manual on Truthfulness. And so the state's position is that those are different things that are required of each one. And under the required evidence test, these two do not merge. Your Honor, further, I would argue that in addition to the Drinkard, and it goes off of a case Blockberger from the U.S. Supreme Court, there's also another thing to look at. And the additional argument is that this actual count, count 6, of violation of oath by public officer, the state's position is that that's essentially like an aggravating charge or an aggravating count. And I say that because you can be charged with making a false statement or any number of crimes, and if you're not a public officer, then that's all you'd be charged with. However, if you are a public officer, then there is an additional thing that is charged. And the legislature set it out specifically. And the state's position is, why would the legislature set it out unless it was meant to be charged, tried, convicted, and sentenced upon? No matter whether, because if you had that, then the argument would be, why pass that law? Why not just charge public figures, whether they're officers or politicians or what have you, that fall under this particular count with the crime that they committed and not the violation of oath by public officer? I mean, why do that? And the reason the state's position is because it's essentially an aggravator. You know, like if you had a hate crime, and the state of Georgia doesn't have one right now, we know, but if it were, that would be an aggravator, and that would be something you'd be sentenced upon. Or if you are a convicted felon, and you are in possession of a firearm, there's an additional charge that you are charged with, and you are sentenced upon that. Possession of a firearm by a convicted felon would not merge into another charge. You'd be sentenced upon it. And here, where you have a public officer, a police officer, who has violated his oath and done that in, probably one of the worst ways you can do, then he should be both legally and factually sentenced upon it, and it should not merge. And
Let me ask you this, Mr.
Yes,
I'm
ma'am.
sorry, I didn't mean to cut you off. How is this different? I understand that some of the elements are different, and you made a valid point of, but for him being a public officer, this count wouldn't even be applicable. But how do you reconcile that against the defense's argument that you can't have 6 without having 5? So basically that they are the same, but it's a false statement, it's one false statement. And so how do you reconcile that?
Well, one of the things is in count 6, there's additional information that needs to be proved, or additional elements that in an effort to fabricate.
5 merge into 6 then, because, and I'm not saying you're wrong or you're right. I'm just asking which 5. 6 is in and of itself stands alone. And I understand there's an extra component that is not there for 5, and that is the fact that it's a public officer. But 5, why wouldn't that merge into 6?
Because under the law, the sentencing would always go into the charge itself, which is the main charge. So it would be making a false statement in this case, which, I understand that's the defense's position, and I understand it. I don't think it's an outrageous argument by any stretch of the imagination based on the law. While there were outrageous arguments, that was not one of them. But our position is that if you look at it from the way I just argued, that it should not. And that's why I also made the second argument of the aggravator type issue, because with the fact that he is a police officer, that is an aggravator, and that's something that the court should be allowed to sentence on additionally to than just the crime itself, which is making a false statement.
Your Honor, I don't think the prosecution's argument is outrageous either, but I think you ought to look at this as being virtually indistinguishable from a case involving felony murder. Obviously, if someone's charged with felony murder, the underlying predicate is aggravated assault, for example. The felony murder has elements that are different than the underlying felony. The question is, when you have concentric circles, in essence, you have a greater offense, like a larger concentric circle, that by necessity, as charged, includes the lesser offense, then they merge. Okay? If the state's right that all they have to do is prove different elements, you would never have merger. Always two different statutes are going to have two different elements somewhere or another. Either a different mens rea, or federal court, you have different jurisdictional requirements. But here, just like in a felony murder case, the underlying felony merges with the greater offense, which is the felony murder. And here, count 5, which alleges the oath of public officer, specifically says the violation was the commission of 161020, which was the false statement. So count 6 requires, by necessity, legally requires every single element of the making of the false statement. So you can't get prosecuted twice. It's just like having a lesser included offense and a greater offense.
So let me interrupt you and ask you this. And looking at the indictment for count 6, it is in violation of the statute that controls false statements, but it also has an and and says the DeKalb County Police Department's truthfulness policy. I know that this is pure speculation for the purposes of this question to you. Could we assume that the jury found him guilty on that because of the violation of the truthfulness policy and not the statute? And would that not make it merge then?
No, it wouldn't. Still 161020 would merge. If there were, we weren't charged separately for the violation of a manual section. That's not a separate crime. So we're talking about merging two crimes here. We're talking about two crimes being sentenced. In theory, practically whether we're dealing with it or not, but in theory, we're talking about getting sentenced twice. Consecutive sentences, 5 years for making a false statement, and 5 years for making the same false statement, including within count 6 entirely. This may all just be academic. If in fact we're not dealing with consecutive sentences, it doesn't, from a practical standpoint, make a whole lot of difference. So I think the problem with the prosecution's argument is you would never have a merger of offenses under their argument. It would never happen. And Drinkard versus Walker doesn't say that. Blocker, the United States Supreme Court president, doesn't envision the abolition of the merger doctrine, really it's double jeopardy doctrine. So we would ask you to merge count 5 into count 6. I have another issue I need to raise.
Well, hold on, let me ask you this, because that's the question that I asked Mr. Johnson, and his position is that 5 would merge into 6. In essence, I guess it's 6 would merge into 5 because it's the false statement. But
5 is the false statement. That merges into the
violation of the public officer.
Because it includes the false statement within.
I agree.
Count 5 doesn't, well, it's a separate argument he's made now, which he never raised before. I would say he never raised before, he didn't have a whole lot of time, but didn't call us last night or discuss with us the issue. But the notion that count 6 is an aggravating factor, as if it were a hate crime statute, but to analogize it to a hate crime statute, the legislature doesn't exactly have imposed sentences when they want to do that. They did it with the firearm statute. They specifically say with regard to many cases, many statutes, federal Congress does it as well. It says, if this offense is committed in a certain way, you automatically get a consecutive sentence. In federal court, all firearm offenses have to be consecutive, 924C. So you end up with consecutive sentences because the legislature specifically said we don't want these to merge. So if you commit armed robbery with a gun, you get prosecuted for the armed robbery and the gun separately because Congress specifically said you do. And Georgia has the same provisions. Not so with regard to counts 5 and 6 here. This is not an aggravator statute. It's not a sentencing statute. It is a separate crime. So I understand their analogy, but it really is pretty far-fetched. If I could just make one more point with regard to count 5, and I apologize, this is late in the game, I'm raising it. There are cases dealing with making a false statement that say if the false statement is an allegation that someone else committed a crime, under the rule of lenity, that is actually an allegation, is a false report of a crime. There's a case called State versus Marlowe. M-A-R-L-O-W.
Okay.
I'm going to give you the citations of that. And it's 339 Georgia Appeals 790 defendant was charged with making a false statement to a law enforcement officer, just like this. And the false statement was that someone else had committed a crime. And that is a misdemeanor. False report of a crime is a misdemeanor. But Mr. Marlowe and his co-defendant were prosecuted, as we were, for making a false statement, which is a felony, needless to say. And the Court of Appeals said, if the false statement is an allegation that someone else committed a crime, under the rule of lenity, you must reduce it to a misdemeanor. And that's exactly what the Court of Appeals did in Marlowe. It reduced the case, it reduced the crime from a felony to a misdemeanor because, as alleged, in that case, and in this case, the allegation was the other person dealing with it. In this case,
The allegation is that assault was made upon, or battery was made upon Mr. Olsen.
that's exactly right. It's an allegation that it was a false statement to say that there was a battery committed by Mr. Hill. And that's what the jury convicted him of. We recognize that. But that is a false report of a crime. Supposedly committed by Mr. Hill. And that is a misdemeanor as opposed to a felony. It has no effect on the aggravated assault charge. It has no effect on either of the office offense. However, if you agree with that, I do, if we get there, and this can be done in a big trial, by the way, it doesn't have to be done today necessarily. Well, I take that back. I don't want to waive the issue that it needs to be done today. There's another case, if we were to follow this along, if you agree that count 5 actually has to be sentenced as a misdemeanor, there's another case that says you can't have an oath of office violation if the underlying offense is a misdemeanor.
What's that case?
I will get very soon. I don't have that up on my computer right now, but I do have it. I just didn't pull it up. It's continuing that.
That's fine. That's fair.
I'll find it. It's a case in which the officer, I take the facts of it, and then I'll give you the site. The officer committed a shoplifting offense, and it was a misdemeanor, and he was prosecuted for violating his oath of office. And the Court of Appeals said, even though it's a crime, and even though it does violate your oath of office, it was a misdemeanor. And the oath of office, you can't be prosecuted for felony for violating your oath of office if the underlying offense is a misdemeanor. You can be prosecuted, but it's reduced to a misdemeanor. So I'm going to get it as soon as I sit down. So
That's fine.
Mr. Johnson wants to respond, certainly has the right to.
So before you respond, so if I understand your arguments and I follow those arguments, what you're saying then is that count 5 would be under the rule of lenity, will be reduced to a misdemeanor with a maximum of 12 months.
Exactly.
And that count 6 would then be void by operation of law because you can't have.
Second, I really apologize, but I can't call it that case. I think what they said was the oath of office gets reduced to a misdemeanor also,
Okay.
as opposed to vacating.
Okay. Mr. Johnson.
Well, having just been handed that argument, considering they had 2 weeks and filed a 73-page document, it's a little troubling, but I'm prepared to respond.
Hey.
I'm prepared to respond.
That's all I want is the response.
Yes, Judge. The facts in this particular case are distinguishable from the facts in those cases, and the reason I can say that is because from what the defense is arguing in those cases, or in that particular case, that there was a fabrication and that it was charged as a false statement, but it was really a false report of a crime, and that it was an attempt to get someone else in trouble. It sounds like they reported someone else committing a crime. It wasn't. This is not that kind of case. This is a case where the person who's making the false statement is making it to cover up a crime they committed. And so this is a corruption issue. This is a lie that is made in an effort to cover up your own actions. That's not a false report of a crime. That is a lie, which is making a false statement, which is what he was found guilty of and what he was charged of. And to reduce it as such would fly in the face of the facts of the case and the jury's verdict in this by finding what he did, because they also found, let's not forget, that he did this in an effort to fabricate his own criminal actions. And so for those reasons, we would state that that should not be reduced under the rule of lenity. And then to go to the second one, with the argument.
Let me stop there.
Yes, Judge.
For the purposes of the argument, the statement as alleged in indictment is that Anthony Hill physically assaulted him, being Mr. Olsen, by pounding on his chest. So pounding on the chest would be a simple battery, correct?
It could be.
All right.
Under the defense's argument, it actually was an aggravated assault. At trial, they argued he was going to commit an aggravated assault.
But for the purposes of our colloquy,
Yes, Judge.
that's a misdemeanor, simple battery.
Yes.
How is that distinguishable from the argument that you just made?
Well, because in count 6, if you
Not
take
count
the...
6, I'm just
well,
talking
no,
count 5.
this is why you have to take the indictment and the facts of the case as a whole. Because we're not just looking at it from an indictment perspective, we're looking at it from a factual perspective. In count 6, he was charged that he made a false statement to Officer Anderson in an effort to fabricate a justification for the shooting of the unarmed Anthony Hill. The jury found him guilty of that. That is why, based on the facts of the case that came out when Officer Anderson testified and we put in his oath of office and we put in video showing him talking to Anderson, which he told the GBI, I never talked to Anderson and no one ever asked me what happened. Those are all lies. That is not a false report of a crime. That is not, someone keyed my car and I'm going to get them in trouble. Well, they really didn't. That's a false report of a crime. This is a corrupt officer lying to cover up a murder. That's what this is, and to reduce it to such would be, in the state's position, ridiculous. And the second argument as to the reducing it because of the oath of office and if it was a misdemeanor, I believe in that case the guy shoplifted like a candy bar or something, the police officer. If we're comparing this case to shoplifting a candy bar, then I don't know where we are.
All right, take away the facts. If the law that came out of that and the precedent that came out of that says if it is a misdemeanor, then it's reduced to a misdemeanor, what do you say to that? Versus if it's like shoplifting for a candy bar or not?
It's a dismissal.
I heard you said it's a dismissal, not a
I
reduction.
apologize. The case is Tullis versus State v. Tullis, Tullis,
Hold on, TULLIS,
LLIS, 213 Georgia Appeals, 581, 1994 decision. And the court actually dismissed the oath of office violation in that case.
All right,
I didn't mean to interrupt that.
Mr. Johnson.
And to answer your question, Judge, whether or not Anthony Hill, under their argument, falsely, I guess, because let's play this out for what it is, falsely was going to commit a battery, or did commit a battery, per the defendant's lie. That's a false statement in and of itself. I get that, and I think
that's
what
why
you're
I'm asking,
saying.
why do you say that? And what I'm asking you to do, and I know it's hard, you don't want to, but just go with me.
Yes, Judge.
Accept what they said. And what I'm saying is accept what they said here today on the motion. You look at the indictment, it's a simple battery. And if that is a simple battery for count 5, what I'm asking you is why shouldn't I follow their argument? And that's what I'm asking you, if not whether it's false. Let's just take the indictment. A pounding on the chest is a simple battery. It may be a battery, depending on if there's a mark or whatever else, if it meets those elements. But either way, it's a misdemeanor. And so what I'm just asking is, if you take Mr. Samuel's argument and the cases that he has cited for, and that is a misdemeanor, what I'm just asking is, why is that not a false report of a crime that he said, he being Mr. Olsen said, Mr. Hill hit me on my chest, or Mr. Hill battered me? Why is that not a false report of a crime? And why is it a false statement? That's what I'm asking. If just taking that for the
Right, for the
purposes
same
of this
arguments I
argument.
just made, Judge, that a false report of a crime would be, I am reporting a crime was committed by someone in order to get that person into trouble.
All right,
A
so
false
the
statement is
distinguishing
made.
is that it has to be made for the purpose of someone else being in trouble, not just making
That's
the
the
intent,
state's
what the intent of having someone in trouble incarcerated or arrested for the crime that they've alleged happened, not for, as you stated in 6, to make a justification claim.
Yes, Judge, the intent is important. And I would, let's not forget either, Judge, that if, I guess the other reason why it doesn't make any sense to treat this as a false report would be because if he committed a battery on him, that would not be a justification shooting someone twice. So clearly his intent wasn't to say he committed a battery on me. His intent was to say he was going to kill me, right? If that's where we're going with this and what he was found guilty of. And I guess my last thing is, this really isn't proper venue for any of this argument. If the defense wants to bring this up in a motion for new trial, we're here for a sentencing. And we've waited a while for this, and we're ready to sentence on what he was found guilty of. So I understand why he's arguing, and I don't, say he can't. Obviously, that's the court's decision, but to raise it orally at this hearing, at this time, I would say that it is more appropriate for a motion for new trial argument, and A, it should be denied based on the merits, just from what we just argued, but B, even if it were to be considered, it should be considered at a later date in a motion for new trial.
But let me respond to that first. I'm fine with that. I just don't want to be accused of waiving anything that would affect sentencing. And to reduce the charge from a felony to a misdemeanor, you could resentence him following a new trial motion. But I have no problem with giving the state full opportunity to brief these issues and address the issues I'm raising. And obviously, we can do that later. I just don't want to run into a waiver argument later. You should have raised this at sentencing. Obviously, in many cases, these issues are raised 5 minutes after the jury comes back, right? I mean, obviously, they're often raised, right after sentencing without much, right after the verdict without a whole lot of preparation time for either side. If you are considering moving on now, and we're going to reopen it as a new trial motion, I have no problem with that. I would point out that false report of crime 161026 has none of the elements that the prosecution wants to add to it. I mean, I'd be surprised if down the road someday the cab DA's office is prosecuting a case involving false report of crime and will concede that we have to prove a motive for it. It's just not in the statute. The statute says a person who willfully and knowingly gives or causes a false report of crime to be given to any law enforcement officer, the agency of the state is guilty of a misdemeanor. It doesn't say it has to relate to somebody else or it has to be with some non-motive or some different motive. It's a false report to a police officer that someone's committed a crime. The allegation in this case is that Chip Olsen lied to the police when he made an allegation that Mr. Hill was committing a crime. That is a misdemeanor. And what Marlowe says is, under the rule of lenity, if that's the crime that's alleged, it's a misdemeanor. It's not a felony. It should be prosecuted. It should be the conviction. Even if there's a conviction on the felony, which is what happened in Marlowe, it has to be reduced and punished as for a misdemeanor. That's the statute. Mr. Johnson wants to add new elements to the statute that don't apply here. It seems like an odd thing for the prosecution to ever do in a case that increases burden by increasing the number of elements that have to be proved. But to finish where I started, the state wants to reserve it for the new trial motion. We're fine with that as long as nobody starts complaining about a waiver issue.
I think that it's more appropriate in a motion for new trial to argue that issue when not only the state, the defense, as well as the court has had the opportunity to look at that. So it will stand as is. As it relates, Mr. Samuel, you get the last word as it pertains to the argument of merger, since it is your motion. The state's position is that the elements are different, and the elements, although it is a false statement for, is the statute contained in count 6, but for Mr. Olsen being a public officer, which is a different element that has to be proved, it is not a mergeable offense.
Well, I'm not going to just repeat the arguments I made, but how would you ever merge a felony murder case? Then it has to be a death with a greater offense, not for aggravated assault. right? So if you have a felony murder with the underlying felony being aggravated assault, the aggravated assault merges into the felony murder. What Pickard versus Walker did is said, once you understand what the two crimes are, if they are concentric circles as alleged, not the facts, but the law, if what Drickard did was eliminated the prior cases that dealt with mergers by just because the facts tended to be the same, or the facts for two different crimes were the same. But if as the indictment alleges, one crime has to have been proven, each element has to have been proven in order to convict for the other crime. If every element of that, what we are calling the smaller crime, is included within the count of the indictment which alleges the greater crime, then it merges. I don't know how to give a better example than felony murder. I mean, the state obviously agrees that in a felony murder case, you don't get sentenced for the underlying felony and the felony murder. You can't get consecutive sentences for aggravated assault and felony murder. You don't get life plus 20. And yet they both have different elements, right? Felony murder's got to have a death. Aggravated assault doesn't have a death. So under their argument, you could start sentencing people for felony murder consecutively, even though clearly the law will not support that. So that's my argument, and we contend with 5
So one more point is, in an indictment, the law is clear that an and can also mean or. And as it's alleged in count 6 of the indictment, it's an and of the false statement statute and the violation of the county's policy of the truthfulness policy. Go with me for the purposes of this question. The jury could have found guilty of violating the truthfulness policy and not the statute. Because you can have inconsistent verdicts here in Georgia, and there's nothing. So, and the law allows that, and there's nothing we can do about that.
Correct.
So I understand what you're saying about count 5, but I'm talking specifically of count 6, because and means or when it's charged in an indictment according to the law. They could have found Mr. Olsen guilty of violating a policy, which is the same as what was in count 4. There was a statute and there was a policy. The statute was not before their consideration based off of ruling, but they found based off of a policy. So in essence, they could find again on a policy in 6, which is, I understand that the statute does not say policy, but that is how it is alleged, and if they're found guilty, that is a different element than a false statement. Would you not agree with that?
I would agree with that. The problem there is I do not know cases that you can have inconsistent verdicts for purposes of having consecutive sentences and then ignore the inconsistent verdicts and say, but they did find him guilty. So what you're saying is the jury could have found him guilty of making a
policy, the statute
policy violation, but not guilty of making a false statement. So we're going to sentence him for the false statement. That's not what Powell said. That's not what the inconsistent verdict rule says, which is that juries do things that they nullify, they compromise, and we're not going to second guess them and say we're going to reform the verdict. And this isn't necessarily the state's argument, but what you're suggesting is that we can interpret this verdict as being that he was acquitted of the false statement in order to convict him of.
No, I'm just saying that that's not what I'm not in any way trying to speculate what the jury's deliberations and their decision was. What I'm just saying is we understand that and means or.
Correct.
And there is another element in the indictment of 6, which is not just a false statement. That's all I'm asking.
Oath of office is bigger. That's the concentric circle that's larger. It's the false statement is the smaller circle in the concentric circle. Right? You have a greater offense and a smaller offense. And what we're saying is you can't prosecute for both. The smaller offense, the smaller circle, is the false statement claim. And I understand that. You're getting interpreted here. What you're saying is you have 2 inner circles, right?
Correct.
One is the false statement, and one is the violating the truthfulness rule. Okay? Maybe you're saying the jury acquitted him of the false statement, that circle, and found him only guilty of the other small circle. Well, that's fine if you want to rule that, but then you can't turn around and say, and therefore, we're going to sentence you for the false statement. Because that's what you're saying is, There could have been a separate reason for this, and therefore we're going to sentence you for both. That's to use the prosecution's term, somewhat of a perversion of the inconsistent verdict rule. That we're going to, for purposes of count 6, we're going to assume you were acquitted, assume it, even though the jury didn't do it, and then sentence you for the one that we're going to assume you were acquitted. That's a bizarre result.
Is there anything, Bernie, that you wanted to add on? All right.
No.
I will say that this is something that I also researched before even getting the states, not the states, the defendants' memorandum and sentencing report. And I don't know that the law allows me to merge them.